Good afternoon, everyone. Welcome to our March installment of In the Boardroom with attorney Andy Phillips and Attolles Law. I'm Sarah Diedrich Kasdorf, Director of Outreach and Member Engagement at the Wisconsin Counties Association, and we are thrilled to host In the Boardroom with our partners at Attolles Law. Today, we have an exciting program for you where we will be exploring Wisconsin's open meetings law. While the open meetings law may not sound exciting on its face, today's webinar will highlight some of the odd and sometimes confounding questions arising under the open meetings law. From members of the public creating a disturbance to issues relating to remote meetings, today's discussion is sure to be thought-provoking and even a bit entertaining. Before I turn it over to Andy, I want to remind everyone that if you have questions during the presentation, please type them into either the chat or the Q&A feature of Zoom. We will be monitoring questions throughout the presentation, but may not be able to get to all of them until the formal presentation is completed. And before this question gets asked and typed into the chat, yes, we are recording this webinar and placing the recording along with the slides on the WCA website. At the end of the webinar, I'm going to have a couple of exciting announcements for you, but for now, I'm going to turn it over to the star of the show, Attorney Extraordinaire, Andy Phillips.
Wow, no pressure. Attorney Extraordinaire. That's great, Sarah. Thanks for the kind introduction. As Sarah mentioned, use the chat and Q&A function to ask your questions. I am remote today. I'm not in my office. I don't have the dual screen set up, and so it's going to be difficult for me to monitor the questions that come in, but Sarah is going to dutifully perform that task for us today. This is In the Boardroom. It's designed to get you the information that you want to see about the question or topic that we are presenting about today. This is not designed for me to talk at you for an hour, so please feel free to ask your questions as we move along here. So without further ado, let's talk about open meetings law. And I'm a bit offended that Sarah said it's not exciting. I think it's incredibly exciting stuff. If it's not exciting, it's incredibly important stuff. And I'm going to lead with a couple of really important points here. So that's the teaser for the next slide. We're also going to talk about issues surrounding the scope of the open meetings law. I think there are some misconceptions about how broadly the open meetings law has been interpreted by our courts and the Attorney General. We're going to talk about peculiar issues with providing notice of meetings. As Sarah mentioned, we're going to talk about remote or virtual meetings and some of the challenges that arise as a result of our meeting in a virtual environment. And then we're going to talk about some of the problems that we encounter through public comment and public participation in our meetings. So here's the important stuff. This is really important. I am an attorney with a law firm. I happen to represent the Counties Association, and I'm privileged to represent many counties around the state, but I'm outside counsel. You have a resource in your county that understands your rules of procedure, understands your board rules, understands local policies and customs. That's your corporation counsel. And so if you ever encounter any sort of question or issue or concern with open meetings law compliance, go to your corporation counsel. He or she is a terrific resource on open meetings law compliance. As well, the Attorney General's office maintains the PROM line, the Public Records Open Meetings Hotline. Attorney Paul Ferguson with the Attorney General's office staffs the PROM line, staffs and handles all open meetings and public records issues for the Attorney General's office. He loves it when people call him with questions. You can even call Paul and try to stump him on some really difficult questions that may arise under the open meetings law, or for that matter, the public records law. Use that resource liberally. That's why the Attorney General has made it a priority to fund that office, establish that office, and have a very, very qualified person sitting on the other end of the phone in Paul Ferguson to help answer your questions. So if you take nothing else away from this, understand where to go when you have questions about open meetings law compliance. And that's what this slide. So let's start with this whole concept of the scope of the open meetings law. And we start, of course, with the language of the statute. And with the language of the statute, it's in 19.81. And this is important. This is important because you don't typically see statements of intent or statements of purpose at the beginning of statutes. But with the open meetings law, and honestly with the public records law as well, we see these statements of intent or statements of purpose. I will tell you that I've had the opportunity to represent several counties and other public entities in open meetings law litigation. The courts always go to this purpose, or policy statement at the beginning of the statute. So it's important to understand. To implement and ensure the public policy herein expressed, all meetings of all state and local governmental bodies shall be publicly held in places reasonably accessible to members of the public and shall be open to all citizens at all times unless otherwise expressly provided by law. The statutes that relate to the open meetings law requirements are going to be liberally construed. That means that they are going to be construed in favor of openness, transparency, and otherwise complying with the intent of the open meetings law. So what I always say is that if we're ever in a position where I and my client have to defend a certain action in front of a court as it relates to the open meetings law, we've got one hand tied behind our back. We know that there is a presumption and there is going to be a construction to the statutes that is going to favor transparency and open government. So understand that. So to whom does the open meetings law apply? And I think everybody understands that, well, it applies to county boards. It applies to county board committees. It's going to apply to commissions that are created within the county and that are required by statute. But it goes deeper than that, okay? The open meetings law has been construed by our courts, according to this statute, to apply to many bodies that I think you or I would sit there and scratch our head and say, well, why does the open meetings law apply to this particular entity or this particular body? Well, the reason it does is if you look at this statute, which is 19.82, I believe, I don't have the statute cite up here, 19.82 sub 1, that defines a governmental body. We have the givens, the county board, commissions, committees, or so on, but we also have a department or public body created by constitution, statute, ordinance, rule, or order, or a formally constituted subunit of any of the foregoing. And so when we're talking about the scope of the law to whom it applies, we look at the source of the authority. Where does this particular body get its power from, and who created it? Because if this particular body was created by a governmental body, if this particular body was provided a charge by a governmental body, then we have a question concerning whether it falls within the scope of the open meetings law based upon that definition in 19.82 sub 1. So again, when we look at how courts have construed this, when we look at how the Attorney General has opined on this, going back to what I first said, where these statutes are entitled to liberal construction, we've even had situations where absolutely purely advisory bodies are subject to the law. In other words, they have no formal decision-making authority, yet they're subject to the open meetings law by virtue of who created them and who gave them their charge. This was from the DOJ's compliance guide. And again, this is another fantastic resource that exists out there. If you just Google search Wisconsin Open Meetings Law Compliance Guide, you're going to find that compliance guide. And I personally have a copy of the Open Meetings Law Compliance Guide and the Public Records Compliance Guide right next to my computer on my desk, because I use that as a resource in handling some of these complex issues. But if we look at the compliance guide as it relates to, again, who created the body, is it subject to open meetings law? It says right in there, state and local bodies created by rule or order are also included in the definition. As we stated earlier, the term rule or order has been liberally construed to include any directive, formal or informal, creating a body and assigning it duties. It includes directives from governmental bodies, presiding officers of governmental bodies, or certain governmental officials like county executives, mayors, or heads of a state or local agency, department, or division. Now, this is from the Attorney General Compliance Guide. This isn't from a case. There has not been a case that has construed every element that's contained within this particular provision in the Attorney General Compliance Guide. Personally, I'm a lawyer, just like the Attorney General is a lawyer. I look at the statute, and frankly, I disagree with some elements here that the Attorney General has put forth. For example, I know of no county, board, committee, anything out there that has ever created something informally. I don't know how that's done. So when we get to that part of the Attorney General's verbiage here, where that statute's been liberally construed to include any directive, formal or informal. I have no idea how an informal directive or an informal order exists. So that's the first point. The second point, and the problem I have with this, is that in the second sentence here, the Attorney General suggests that a county executive, for that matter, a county administrator, or some other part of administration within county government, has the authority to create a body that would be subject to open meetings law. I have no idea what gives a county executive, an administrator, or another the authority to create an official subunit or body that would be subject to the open meetings law. Now, there is all sorts of discussion in the compliance guide, and I encourage you to go take a look at it, about various advisory groups to a county executive or a mayor or other things of that nature. And so I can see why, from a public policy standpoint, we might want the law to apply to those advisory groups. But again, coming back to this notion of statutory interpretation, I don't know what gives a county executive or a mayor, for that matter, the authority to create a body like that. So that aside, I say all this to say that I happen to disagree with some of the statements in here, but the statements are in here for a reason, and that is to put everybody on notice that the statutes are going to be liberally construed. And in a case where we don't quite know if it's a gray area, a court is going to turn the presumption and say the presumption is that we have transparency and that we have open government. We had an opportunity to litigate the scope of the open meetings law, to whom it applies, in the Krieger versus Appleton School District case. Went to the Supreme Court a few years ago. My firm, we represented the Appleton area school district in this Krieger issue that went to the Supreme Court. I like to say that we won 2 out of the three cases. We won at the circuit court level, we won at the Court of Appeals, but we ended up losing at the Supreme Court. And so if we look at what the Supreme Court did in the Appleton School District case, it is very instructive as to some of the concerns that we ought to be aware of as it relates to this question of scope. All right, first, we have to determine what committees are created by rule of the governing body. And when we say something is created by rule, you look at ordinances, you look at bylaws, you look at board rules, you look at resolutions, you look at policies, you look at handbooks. In other words, has the governmental body, the governing body, established some sort of written process by which a particular committee, and frankly, it doesn't have to be called a committee, it can be a task force, it can be a blue ribbon task force, it doesn't matter. What created this particular entity, and was it by written directive? Ensure that your policies are consistent with your practices. And that is, if you have a written document establishing a particular committee, task force, blue ribbon task force, commission, whatever, then make sure that everybody is aware that the open meetings law is going to apply to that particular body. And if you do not intend to create a committee or another body that is going to be subject to the open meetings law, then don't have it in your written resolutions, policies, handbooks, and so on. I'll give you the most absurd example I can think of. Imagine if your employee handbook allows certain employees to create a sunshine club. In other words, the employee committee's entire role is to collect 50 cents from all of the employees in the courthouse every month, and then at the end of every month, buy donuts for everybody, to spread goodwill, to spread cheer, to spread sunshine. That's why sunshine clubs exist. Well, if that sunshine club has official recognition within the employee handbook, is that the type of club or committee or task force that is going to be subject to the open meetings law? Potentially. If you look at the Krieger case, I think there's an argument that anytime those employees get together and talk about what donuts they're going to buy at the end of the month, they have to notice that meeting. Again, I think that's an absurd example. That's an example that extends the open meetings law far beyond what was intended by the legislature. Nonetheless, we can see with the Krieger case how that process goes. This is again from the DOJ's compliance guide. In talking about the Krieger case, and again, this is the DOJ's take on the Krieger case, the Supreme Court explained it doesn't matter that two individual district employees decided on their own to put into place the rule and handbook policy, informing the particular committee they formed. And just by way of background, what happened in Krieger is that it was a committee that was established at the employee level, not at the higher ups in administration, certainly not with the school board, but at the employee level, to read and review all of the books that were contained on the 9th grade, I think it was English class, the reading on the 9th grade English classes reading list. So in other words, they were just doing a review of what books should be on that reading list for the 9th grade English curriculum. Wasn't changing the curriculum, wasn't formally amending the curriculum, nothing like that, just going through the reading list. So these employees said, you know what, we ought to get together, we ought to review this book list. And in doing that, they looked at the school board policy on curriculum and said, hey, you know what, that's a pretty good process. Why don't we follow that informally? They did that, and that was the problem. Because again, this DOJ's take, didn't matter that neither the board nor the handbook policy had provisions that created or even mentioned that informal committee. Didn't matter that the committee deviated from the handbook's procedures in making its recommendations to the school board for a course's curriculum. Rather, the dispositive factor, meaning the reason that the court ruled that this particular body was subject to open meetings law, was because the handbook policy authorized a review committee to be created for the purpose of reviewing curriculum materials and making the recommendation to the school board for adoption. So again, pay attention to your rules, pay attention to your handbook, pay attention to your resolutions, pay attention to your ordinances, and wherever it says in there, hey, you're authorized to create a working group to do this, or a committee to do this, or a task force, whatever. Understand that that particular body that is created as a result of the ordinance, handbook, rule, process, procedure, whatever, could be subject to open meetings law. So from a scope standpoint, we understand what entities are going to be subject to the open meetings law. We have to get into then, well, what is a meeting? Okay. So this is in 19.82 sub 2, the definition of a meeting. The convening of members of a governmental body for the purpose of exercising responsibilities, authority, power, or duties delegated to or vested in the body. If one half or more of the members of a body are present, the meeting is rebuttably presumed to be for the purpose of exercising the responsibilities. All right, so based upon this statutory definition, we have what's called the Showers test, and that comes from a 1987 Supreme Court case, State XRL Newspapers versus Showers. And I always refer to it as the 2 Ps, all right? In order for a meeting to occur, the 2 Ps have to be present. First P, purpose. Is the gathering of those individuals for the purpose of engaging in governmental business? If those individuals are gathered for the purpose of watching the Green Bay Packers play, there is no meeting because you have not satisfied the purpose element. But the second part of the Showers test, the second P, people. Are there a sufficient number of people present to determine the governmental body's course of action? And so again, if you satisfy the 2 Ps test in Showers, you're going to have a meeting. And so when we look at what types of meetings are going to be subject to open meetings law, we have a series of cases talking about the different circumstances that are going to trigger the open meetings law because the 2 Ps are met, so to speak, the Showers test. Governmental business refers to any formal or informal action, including discussion, decision, or information gathering on matters within the governmental body's realm of authority. That's where we get into the bag key case, this whole concept of information gathering. And I think a lot of you are very well aware of what we call bag key notices contained within our agendas when we notice a meeting. Those bag key notices typically say something along the lines of a quorum of one or more committees of the county board may be present at this meeting for purposes of listening to the meeting, but no official action will be taken by that committee. All right, that's a bag key notice. And again, not to crawl too far in the weeds, the Attorney General has taken issue with the bag key notices as it relates to an informal opinion that the Attorney General issued. But nonetheless, it's the bag key case that causes us to put that notice at the bottom of agendas. And in bag key, what you had is you had members of one governmental body traveling to a meeting of another governmental body, different jurisdiction, all right? So it'd be the same as the village board coming to the county board meeting. And that other governmental body was listening to what the governmental body was debating and discussing and taking action on for purposes of informing that governmental body's action at a future meeting. Court said, you know what, that's a meeting within a meeting. You had to notice it. There had to be an agenda. You had to have all of the attributes of a meeting when you went and attended that other governmental body meeting. All right, so be aware that when we talk about, again, liberal construction of these statutes, and we talk about how courts and the Attorney General view these open meetings law requirements, the definition of meeting has been given a very expansive definition, all right? There have been cases out there, I've been involved in litigation where we've argued as to whether there was a meeting or not in circumstances similar to Bagke. Polton v. Volkman is one of those cases where the court said, look, no meeting occurred, even though a quorum of school board members attended a gathering of town residents. They didn't collect any information on a subject that the school board even had a potential to decide. They were interested citizens. And so again, if it's just folks gathering for purposes other than governmental business, that's not a meeting. But if they're there to gather information, even if it's informally, that may impact their future action, you better be concerned about open meetings law compliance. All right, so we've talked about purpose. Let's talk about people, the other P in showers. All right, and this is where I get a lot of questions too. It's not just a determination of quorum. So in other words, if we have a 21 county board, as long as we keep membership at another meeting or gathering to 10 or less, we don't have to worry about open meetings law compliance. That's not necessarily it. We have concepts related to negative quorum. We know that, for example, in certain circumstances, county boards are required to act by supermajority vote. If you're going to borrow money, you got to act by 3/4 vote in order to adopt that borrowing resolution. Well, in that circumstance, anything more than 1/4 of the membership can direct the course of action as it relates to the county board action on borrowing because they can defeat that measure. And so that is considered a negative quorum. The other issue that we get into, and I'll use a simple example here. We have a committee of 5 members. How many people out of that 5 have the power to direct action? And typically I get the answer, well, 3. And my answer is always 2. Why is it 2? Well, think about it. If our committee is comprised of 5 people, a quorum of that committee is 3. So if there are 3 people present at the meeting, how many votes do you need in order to adopt a measure? 2. And so 2 could be sufficient to hit the people requirement that was established in showers. And so again, you've got to be very careful about how you define and how you implement the second P of the showers test, the people requirement. Quorums, a walking quorum. A walking quorum is another danger under the open meetings law, which is why the Attorney General tells us to avoid these walking quorums. According to Showers and according to the Attorney General, a walking quorum is a series of gatherings among separate groups of members of a governmental body, each less than quorum size, who agree tacitly or explicitly to act uniformly in sufficient number to reach a quorum. I read that definition of a walking quorum for a reason, because I would like somebody at some point in my career to show me the difference between the definition of a walking quorum and the definition of politics. That definition of a walking quorum aligns precisely with the definition of politics. And so I can sit here, whether it be an in-person discussion with you all or in this webinar, whatever, I can sit here and say, as a lawyer at Attolles Law who represents counties in the WCA, don't ever talk about county business outside the walls of the courthouse. Never do that. You should never do that. And if you do, I'm going to chastise you. That's very easy for me to say. Really easy for me to say. But what happens when you're sitting at home one night and you have a couple of knocks on your door and it's a couple of people from down the road that want to talk to you about an issue with the county? And before long, you've got 3 more people that show up and want to talk about that. Some citizens, some other board members, some on some committees, some on other committees. I know that life happens. I understand that. But the better we can understand these issues, the better we can understand the definitions associated with negative quorum, associated with walking quorum, the more aware we're going to be of all of these dangers associated with the open meetings law, and the less heartburn we're going to give corporation counsel. And speaking lawyer to corporation counsel, we don't like heartburn. That's not fun. So again, let's try to avoid these issues, these discussions, as much as we possibly can. All right. We all know the danger with walking quorums. We know that it leads to a potential predetermined outcome. I will tell you that there is one group of people, one segment of society who is going to have their antenna up as it relates to walking quorums. It's going to happen in a county board meeting when a particularly contentious item comes to the county board floor and there is zero discussion and it goes straight to a vote. And that particular segment of society with their antenna up is going to be scratching their head saying, well, how is it that we can have such a contentious issue in our community and there's zero debate on the county board floor? I wonder if there were discussions that happened before the meeting. That's the press. The press is going to be on the lookout for these sorts of things. And so don't be surprised if that circumstance happens to you where there's no debate on the county board floor in a particularly contentious meeting. Don't be surprised if there's a public records request for all email correspondence, text messages, and so on that predate that county board meeting, because they want to figure out, was there a predetermined outcome here? The other thing we can't do is we can't use third parties that aren't members of the county board to run around and poll people and figure out how people are going to vote on things. We can't use those surrogates to circumvent the open meetings law. Quick word about petitions. I just said you can't use petitions to circumvent the open meetings law, but in the statutes, we have the ability to call a special county board meeting if more than half of the supervisors sign a petition requesting that special county board meeting and provide a statement to the county clerk as to the purpose for that meeting. Does that petition constitute a violation of the open meetings law? No, it doesn't. We can always circulate a petition asking for a meeting that contains the subject matter of the meeting. As soon as that petition crosses over and moves over into advocacy and suggests how particular people should vote on a measure, then we have an issue under the open meetings law. But the mere fact of a petition circulating asking for a meeting is not going to cause problems under the open meetings law. Email, it's written. So what concern do we have with emails as it relates to open meetings law? Well, we got a concern because it's a very instantaneous way to be in communication with potentially a quorum or negative quorum or walking quorum of the entire county board or a particular committee of the county board. Email is valuable, email is quick, email, it serves a great purpose in keeping in touch with folks, but it's also very dangerous. And so avoid talking about county business over email. And definitely, if somebody sends out an email, don't reply to all with thoughts and further comments on a particular subject. That creates problems under the open meetings law. And so it's in the Benson correspondence from 2004. So this is going back almost 20 years now. A violation may occur if officials are in instant messaging or emailing in close time frame to determine a potential course of action for the body. So just be aware of this. So I always say, don't engage in discussions over email about county business. This is an example. This is the war stories. This is the actual text message chain from a Madison City Council meeting. And so if we look at what was happening during this Madison City Council meeting, we again had the press monitoring the city council as the meeting's going on. And the press saw that during the meeting, there were a bunch of members of the meeting that were sitting there like this as they were listening to business. And they'd sit down, they'd chuckle, and then they'd text one another again. And so a very smart person from the press decided to submit a public records request for all the text messages that were going on during the meeting. Well, look at what was produced as a result. The meeting is so peaceful with Bridget not speaking to me. You are a hoot. You really have no idea the difference her silence makes. Smiley face. Help. I can't always carry it all on my shoulders. I've really done nothing but help. All of these things were during the meeting between the council members. Let's avoid using electronic devices other than our county issued iPad for purposes of the agenda. Let's avoid using our phones and other electronic devices during meetings. Put them away. They only lead to concerns and issues. All right, so we're going to move on. We've talked about liberal construction of the open meetings law. We talked about the important stuff with corporation counsel and the prom line. We've talked about the triggers under the statutes as it relates to the definition of meeting and definition of governmental body. Now let's talk about some of the peculiars that relate to providing notice of meetings, because one of the hallmarks of the open meetings law is that we provide the public of notice of a meeting, notice of what we're going to be doing as a governmental body. That promotes transparency. And so we look at the general rule on meeting notices. They have to be reasonably specific with regard to agenda items so as to reasonably apprise the public of what will occur at the upcoming meeting. Different counties do it different ways as it relates to providing notice to the public, and that's okay. But the question that you have to ask yourself, and this is a great question for whoever is in charge of agendas and posting notice to the public, is does the language in this agenda, in this notice, reasonably apprise the public of what will occur at the upcoming meeting? Now, there's an entire case on this. It's State Ex Rel. Buswell versus Toma Area School District. It's from pre-2010. I can't remember the exact date, but it goes through a litany of examples that you need to take into consideration as it relates to what is going to reasonably apprise the public of what will occur at the upcoming meeting. I didn't put that in here because if you ever have a question about what is going to reasonably apprise the public, you need to talk to your corporation counsel. Your corporation counsel will interpret and apply that Buswell case, and it's very important that you ask those questions, all right? So where do we post it? Our statute gives us the right to put it on our website and then post it in one other place where the public is going to be reasonably apprised of the existence of the meeting. Absent posting on the website, post it in 3 different spots. I think everybody understands the posting requirement. There is no publication requirement. You don't have to take a paid advertisement out in the newspaper advising people of an upcoming meeting. If you want to do that, you can. But I think that when we talk about the whole concept of notice, again, go back to the very beginning of this discussion, where we said that the statutes are going to be liberally construed. And so a court is going to look at this and say, did you apprise the public of what you were going to do at this meeting? And did the public have reasonable advance notice of the existence of this meeting? All right, so make sure you can answer those 2 questions in the affirmative.
Andy, I just want to stop you here real quickly because we just got in a couple of questions about notice that I think fit in right here with this slide. So the first one, is there a notice requirement for meeting cancellation?
No, but I think it's common courtesy to let folks know that a meeting has been canceled. You can frankly convene the meeting and adjourn without doing anything. You didn't take any action. You didn't exercise any governmental authority. So I think that's fine. But as a matter of courtesy to the public and to the press, you let folks know that the meeting is going to be canceled as soon as you know that it is going to be canceled.
All right, and one other question, and I don't know if this is coming later on in your presentation or not, but it says, should there be specific language on agendas as to whether or not there will be action on an item, or is it reasonable to assume that action is possible on all items?
Well, Sarah, you know what I always say about when we assume things, what happens, and so I never like to assume things. If we are going to set up our agendas so that any item on the agenda is subject to action, just put it at the top or the bottom, put little asterisks there to say any item on the agenda may be subject to action. Otherwise, if we're just going to discuss something and it just says discuss on the agenda, I don't expect official action. And if I am the legal advisor to that particular board or committee, I will say you cannot take official action as it relates to this item on the agenda because it was just noticed as discussion. So again, let's make sure that we are accurate in the notice that we are posting. All right, continuing on. I get this question quite a bit. What happens about tours? I mean, at the beginning of every term of office of new supervisors, we like them to go on tours of our jail and tours of our courthouse and tours of the zoning office, tours of the highway facility. What do we do about open meetings law compliance? And for that matter, we may have a highway committee that every summer likes to go out and take inventory of how our county roads are doing. How do we deal with that? That can be a particular problem. That's a challenge because if that committee is gathering as a group getting in the same vehicle and driving around to look at stuff, chances are they're going to be talking during their travels in an effort to better understand what it is that they're looking at. That is a problem because the public has a right to monitor, not participate, but monitor what's happening within that meeting. So let's be very careful about what we do with tours. I do not personally like county boards going on a lot of tours unless we have a specific schedule for them. We have administration involved in that scheduling. We have department heads and other constitutional elected officers involved in that process so that we can ensure that to the extent possible and practicable, we provide the public with the opportunity to monitor those particular meetings. And so I don't like doing a lot of those. I know in certain circumstances, they're going to be required. For example, if a Board of Adjustment is going to want a site visit when determining whether to grant or deny a variance, we notice on the agenda that a site visit is going to happen. We have the Board of Adjustment members travel separately to the site. And when we get to the site, we provide time for the public to arrive and monitor what it is the Board of Adjustment is looking at on that site visit and to listen to what the Board of Adjustment is talking about at that site visit. And our agenda lays out quite specifically timeframes when we are going to be doing these site visits and returning to the actual meeting room. And so I prefer to be very specific on the agenda as to exactly what is happening. If we're just getting in a car and driving around, it's very difficult to build out an agenda and provide the public notice. And in addition, it's incredibly difficult to allow the public the opportunity to monitor what's going on. So I am not a huge fan of these tours. It depends on your county and what practice is in your county. But if you want to continue with these tours, I highly, highly encourage you to talk extensively with administration, constitutional officers if they're involved, department heads, and definitely corporation counsel about how you make sure you comply with the open meetings law as it relates to these tours.
All right, Andy, before you switch to the next topic here, quick question. Would you be able to give us some specific ideas or examples of just how specific agenda items need to be?
Yeah, and so that's a great question. There's no one size fits all. The Buswell case doesn't give us the template for an agenda. And so it's all about reasonably apprising the public. It's a challenge, especially when we get to, and I'll get to this later in the presentation, when we get to closed session. All right, so we adjourn into closed session. How specific do we have to be about what we're going to discuss in closed session? And again, I've gone back and forth with the Attorney General's office and several DAs around the state too, because sometimes they are suggesting, they being the AG and the DA, that we have to be incredibly specific on the agenda. But I will tell you right now that in smaller counties, if I say that I'm going into closed session to talk about a disciplinary issue in the treasurer's office, I'm talking about one employee. What's the purpose of going into closed session? I'm just letting the employee know exactly what we're talking about in closed session. Everybody knows who it is. So what's the point of closed session? And so you got to kind of have a balance there as it relates. If the most absurd example is to have an item on the agenda that says, discuss and take action on any other business allowed by law. That's overly broad. That's never going to cut it. That's not okay on an agenda. All right, that's too broad. At the same time, if on the agenda you say, discuss and take possible action on matters relating to the highway department and the determination of wage rates and classifications of employees in the department, that's perfectly acceptable. Public knows exactly what you're going to be talking about. You get to that agenda item and you start talking about leave policies, you might have a problem because your agenda said wage classifications, your agenda said wage rates. It had nothing to do with leave policy. So you got to avoid the leave policy discussion unless you put in that agenda item that you may also talk about leave policy. So again, talk to your corporation counsel about what is going to reasonably apprise the public as to what business the governmental body is undertaking at a particular meeting. All right, just want to make this known because we get this question quite a bit too. The public has a right to record what's going on in the meeting. Film, photograph, video, audio, all of that. The public does not have a right to interfere with the orderly operation of a meeting. And so again, it's a fine line. The public has a statutory right to record. Public does not have a statutory right to interfere. All right, so you have to be careful about that, but you can't shut somebody down just because they want to record a meeting. Notably, that doesn't extend to closed session, that statutory right to record. So if you are in closed session And for whatever reason, somebody in that closed session wants to record, you can tell them to turn off the recording device. All right, who can close a meeting? This is an important part too. Only the board can exercise the right to convene in closed or executive session. No member of the public has a right to close a meeting. And that's true even under 19.85(1)(b), which we'll talk about in just a minute. There are 11 exceptions contained in 19.85(1) that allow you to get into closed session. I've listed them out here. Some are more applicable to counties than others. The ones I usually see are 1C, dealing with personnel issues. I see 1G, conferring with the attorney for the county with respect to litigation in which the county is or likely to become involved. All right, so that's 1G. But then we also have this 1B and 1A, and there are special rules under 1B and 1A. 1B is the hearing statute, 1A is the deliberation statute. Under 1B, you have to provide specific notice to a particular person that is the subject of the hearing, and then that person that is the subject of the hearing has a right to demand that the hearing be held in open session, but has no right to demand that the hearing be held in closed session. And so 1B, we have the hearing, and then as the body is going to deliberate as a result of that hearing, we convene in closed session under 1A. Closed sessions are an exception, not the rule. The exceptions are going to be narrowly construed, whereas the other statutes in the open meetings law are liberally construed. So make sure that when you are noticing something for closed session, that you confer with corporation counsel to make sure that you have the right verbiage on the agenda, that you're convening in closed session for the right purpose on the right step under the right statutory exception, and that all of your discussions in closed session fit within these exceptions. You can't just get into closed session and talk about anything you want to talk about. You can't do that. You have to limit your discussions to only what is contained on the agenda as the reason you are going into closed session. All right. Who can attend closed session? Typically, it's only people with the need to know. That's what I always say the standard is, with the need to know. As soon as we start letting everybody in a closed session, what's the purpose of having a closed session? So it's only need to know. What's the penalty for somebody who violates the confidentiality obligation that is implied as a result of the closed session? There is no penalty provision in the statutes. It certainly could be an ethics issue. It's certainly an issue for the governing body as it relates to this member talking about things outside of closed session, but there is no open meetings police that are going to come and arrest somebody for disclosing what was discussed in closed session. I want to make sure that that's clear. We're going to move on to virtual meetings because I know that we've got some slides we've got to get through here. Virtual meetings provide an opportunity for governmental bodies to meet in a convenient way on short notice. But understand that virtual meetings are not treated differently under the open meetings law than regular meetings. So all of the normal rules that apply to regular meetings in person apply to virtual meetings. So we have to provide notice of the meeting, but the notice of the meeting is going to be different for a virtual meeting. The notice is going to talk about how the public accesses that virtual meeting for purposes of monitoring what happens in that meeting. So if we have a Zoom set up like this webinar, we're sending out the link to the Zoom. And then the question comes up, well, if we send out the link to the Zoom, do they have the opportunity to unmute themselves and talk? Well, if it's a Zoom conference call, they do. If it's a Zoom webinar like this, you can't just simply unmute and talk. So I would suggest that if you're going to have a meeting by Zoom, that you do it in the webinar format so that the public can monitor, but they don't have the opportunity to participate. There are some practical pointers coming in here that I'm not going to discuss in detail, but there are logistical difficulties associated with running a compliant virtual meeting. So make sure that these practical pointers and others are followed. We want to make sure that we comply with the open meetings law. We have the ability to go into closed session in a virtual environment. There are platforms that have this concept of a waiting room where you can take people out of a virtual meeting and put them in the waiting room. All I will tell you is be very careful with that, because we want to make sure that we are not inadvertently admitting people to a closed session that don't belong there, and that we are not inadvertently excluding people from a closed session that belong in that closed session. So again, the whole point of these practical points and closed sessions and so on is understand your technology have somebody that understands the technology very, very well, and make sure that that person is available to monitor and make sure that we are holding our meeting in a very compliant fashion. What about public comment? What do we do about the unruly people that want to disrupt our meeting? As a general rule, nobody has a right to disrupt a meeting, okay? But there are constitutional considerations that come up if we provide a forum for the public to provide input to the governing body. Typically, what I see as the forum to provide input is this thing on the agenda called public comment. So what is it that we can do with public comment to ensure that the public acts in an orderly way so we don't have chaos? Let's start with some basics here. Public has no statutory or constitutional right to participate in a meeting of a governmental body. That's important because you could eliminate public comment from all of your meetings. Whether you want to do that is a different story, but legally you can eliminate it, all right? So understand that. So if we can eliminate it, that means that we can put boundaries on it. That means we can create rules related to public comment. And so sometimes we have board rules that say public comment, for example, has to be germane to an item on the agenda for the board. All right, the public can't just comment on anything they want to comment on. It has to be germane to the agenda. We may have a board rule that speaks to this concept of avoiding obscenity, avoiding confrontational type verbiage in public comment. We can have that board rule as well. But again, understand that there are constitutional limitations that may come into play. All right. These are from some cases that I just pulled and put into this particular presentation. Understand that the public comment period it's considered a limited public forum under the law. Why is that important? Well, limited public forum has a special meaning under the law, meaning that even though it's a public forum where we are going to provide people with a First Amendment right as it relates to the exercise of their free speech rights, within that context, within that public comment, it's a limited public forum, meaning that we do have the ability to enact viewpoint neutral regulations on the speech that is exercised during the public comment period. What do we mean by viewpoint neutral? We can't discriminate on the basis of a prohibited basis of discrimination as it relates to people speaking. And when I say prohibited basis, I'm not talking about Title VII in the employment context. I'm talking about you can't discriminate based upon Democrats or Republicans or US citizens versus non-US citizens and so on. It has to be viewpoint neutral, okay? Is the regulation of speech as it relates to use of obscenities and avoiding confrontational language, is that considered a legitimate government interest that would be viewed as a viewpoint neutral limitation on somebody's free speech rights in this limited public forum? Yes, yes it is. So we can have these regulations. Imposing restrictions to preserve civility and decorum are necessary to further the board's purpose of conducting public business, all right? So in Steinberg, in this case, the court upheld the validity of a rule that required a speaker during public comment to address only items germane to the agenda. So when I always offer that as a suggestion to counties, corporation council boards, and others I talk to, I'm offering that suggestion based upon this case and knowing that that type of restriction has been upheld historically. Here's where we get into some of the particulars that can be a little bit overwhelming and difficult to think about, because some of the terms that are used in these court cases and that we use, frankly, in everyday conversation are difficult to understand definitionally. There are different definitions. Can we define obscenity? Is it easy to define obscenity? I mean, even our Supreme Court back in the day says, I can't define pornography, but I know it when I see it. Well, it's kind of like with obscenity, isn't it? What may be obscene to one person is not obscene to another. Whatever we do in terms of the rule, I would very much prefer that we have these definitions within our board rules that are published and available to the public, and the public is on notice of exactly what it is that we are prohibiting, rather than just relying upon some sort of ad hoc determination at the time of public comment, all right? I think it's a lot safer to define that within our board rules. So when we talk about public comment too, we can impose a time limit on speakers. I know many counties do this as well. Again, let's do it within our board rules. That's the best opportunity. It's probably okay if we announce a time limit at the beginning of the meeting, but if we start cutting people off in the middle of their comment based upon an arbitrary rule that we just decided upon that day, we're going to have a problem. We're going to have concerns. All right. Signs and t-shirts and other things that people wear or bring to a meeting. Same analysis as it relates to First Amendment concerns. It's a limited public forum, and so we have the ability to regulate, but we must do so in a viewpoint neutral manner. And ultimately, the question is going to be, does the sign, does the banner, does the t-shirt, whatever, is this something that is going to pose a disruption to the orderly transaction of business at that governmental body's meeting? If the answer to that is yes, we have the ability to regulate. But as I note on this slide, this area is a minefield from a constitutional perspective. So work with your corporation counsel extensively. Here's an example of a rule that was upheld by a court. It's going to be unlawful for any person in the audience at a council meeting to do any of the following. 1, engage in disorderly, disruptive, disturbing, delaying, or boisterous conduct, such as, but not limited to, hand clapping, stomping of feet, whistling, making noise, use of profane language or obscene gestures, yelling or similar demonstrations which conduct substantially interrupts, delays, or disturbs the peace and good order of the proceedings of the council. That sounds really good, but look at all of the room for interpretation within this rule. All right. Understand that you're not going to be able to answer every single question that comes up as a result of having a rule like this on the books, but I personally would much rather you have a rule on the books that you are enforcing within the good judgment of the body in order to conduct an orderly meeting, that we are not going to allow that person to disrupt the business before the county board or the business before that committee. I'd rather have this rule on the books and enforce that rule rather than just making an ad hoc determination at the time of a meeting. If we don't have these rules, this is what could happen. This is a picture of the Ukrainian parliament from about 12 years ago, I believe. It got a little disorderly during the conduct of that meeting. And so our goal ought to be to avoid having this circumstance happen to us. So now I've rushed through a ton of slides and a ton of information. Again, I'm sure there are a lot of finer points that we can discuss, and I'd be happy to discuss that with you, but we've left 8 minutes or thereabouts for questions and hopefully discussion as it relates to the open meetings law and these concerns surrounding public comment. So Sarah, do you want me to start going through the questions, or would you like to do that?
Oh, that's completely up to you, Andy.
Wow, that's
I
great.
mean, I can go through them if you like. I've been monitoring them throughout.
Well, no, I can do that now, because now we're on the slide with questions, comments. I can monitor this. So let me start at the top of the chat function first of all. First, I thought this would be a follow-up to last month's meeting covering solar farms. This is a teaser. Sarah's going to address that in just a moment. All right. Sarah has posted in the chat how to contact the Office of Open Government and how to access the compliance guides I referenced. Please, please, please cut and paste this particular address in your web browser and bookmark it. It's a great resource. Suggestion on emails from Joe. When I email the whole board or the entirety of a committee, I always send it blind copy to everyone, so there's no risk of reply to all. Fantastic way to go about business. I know Joe is a corporation counsel, so he is fully on top of these rules. Question, can a committee use a collaborative document to efficiently make edits to policy documents outside of a meeting, or does it need to be scheduled in advance? I would avoid the use of a collaborative document. That's an invitation for a meeting to occur where people are simultaneously making edits to documents. If you're going to edit a document, if you have notes to a document, if you have suggested changes, write them down yourself and bring it to a meeting where you can discuss those changes. I know that in today's world with technological advances, that seems absurd. It seems like a waste of time, but how in the world is the public ever going to monitor a shared document? Are you going to give that access to the entire public? Because if you're not, you got an issue under the open meetings law. Can staff put restrictions or limitations on public input or rules, or can that only be put on by the committee? The staff can recommend to the committee. And so I think it's always a good idea. If staff thinks that we would have more efficient meetings if we did X, Y, or Z, share that with the committee, share that with the board, but ultimately it's up to the board or the committee to establish those rules for itself. How detailed do meeting minutes need to be? For example, if the board votes to increase staff's number of vacation days, do we have to give exact details? The minutes should reflect the business that occurred at a particular meeting, and the statutes require us to have an official record of whatever business occurred. The statutes, neither the statutes nor Robert's rules suggest that we have to have a detailed transcript of comment, discussion, debate, and so on that occurred during a meeting. So I like to limit the minutes to the actual business that was transacted at a meeting. And if it was only a discussion, put on the minutes that discussion was held, something like that. So it's an accurate reflection of what happened, but I don't like to get into details in the minutes. All right. So if I call another board supervisor to ask a question to gather information on a subject that a committee that member is serving on that I don't serve to understand what that committee's intent of that committee's decision, is this a violation of the walking quorum law? First of all, there's no law on walking quorums. Walking quorum is a concept that is embodied within the open meetings law. So I want to make that clear. We don't have a statute to turn to that tells us how to comply with the walking quorum rules. That's first. But second, calling that particular committee member alone and one committee member may not be a problem under the open meetings law. And I say may because it depends upon other committee composition and so forth. But what I would rather see is I would rather see people attending other committee meetings, whether it be remote or in person, if there is a particular question or concern on items that are on an agenda. And so I want to encourage people to participate. I want to encourage supervisors to understand what is before them on the board floor. And one of the ways they're going to do that is to actually attend the committee meetings where those committees roll up their sleeves and make the difficult decisions on policy that is going to advance to the county board level. And so I really want to encourage that. Now, me encouraging that, I fully understand that that leads to other challenges under the bad key case. And so do we have to put on the agenda things like, hey, quorums of other committees may appear here and they're not going to take any official action? Yes, work with your corporation counsel on making sure that our agendas are properly put together, but I would really like to see county board members attending other committees that they're not involved with, other committees, so they have a great understanding of what's going on at the committee level. How do I handle state mandated jail tours? Well, I do the best I can. I say that county board members are going to tour the jails. They're not going to have discussion on those tours of the jails. They're not going to ask questions. We know that we can't invite the public with us on those jail tours, that it's a secure environment that we can't let the public into. So I do the best I can under those circumstances. Is it okay for a committee to use an extremely generic committee agenda for regular meetings? I mean, it depends on what the term generic means. I mean, you can use a generic agenda, again, as long as it reasonably provides notice to the public of what you are going to be discussing at the committee level. Can the county board require members of the public wishing to record to inform the board? No, you can't do that. They have the opportunity to record, and they don't have the opportunity and the obligation to provide advance notice of that. However, again, let's get back to that concept that they don't have a right to unduly disrupt the board or the committee. Can a board supervisor that's not on a committee participate in a closed session of a committee they do not serve on? There is a statute on that, 19.89, I believe it is. And that statute says that in a closed session, the committee cannot exclude the member of the parent body. In this case, it'd be the county board, absent a board rule allowing for that exclusion. Now, personally, I typically do not like allowing all board members into a closed session of a committee. For example, you might have a complex personnel issue that might lead to litigation that you want to discuss in closed session. And the more people that know about it, the more dangerous it is, so to speak. And so I always like to have a provision that allows the committee to vote to exclude members of a parent body from a committee meeting, but different counties may view it different ways. And ultimately, there's no right or wrong answer on that. It's a policy decision that you and your county make. Does the law require a quorum of members to be physically present at a meeting that is also hybrid with some members participating virtually? Physical presence can be defined within your board rules as virtual presence. You cannot be physically present at a meeting by virtue of being there virtually unless your board rules allow for you to be personally virtually present. That's within Robert's rules. And so the answer to the question is, does the law require that? Yes, unless you have a board rule that says that people can be present virtually. Next, if county board members utilize personal devices, cell phone, personal email for county business, does that subject the entire device to a public records request? Yes. The location of the information has no bearing as to whether that information constitutes a public record. Next, if you hand out materials during the meeting, do you need to also share those copies with the public? You don't have to. There's no requirement on that. But I think, again, in an effort to promote transparency and make sure that nobody accuses you of, quote unquote, hiding the ball, that is something we would want to share with the public. And so to the extent possible, I would want to make those materials available to the public. They're subject to a public records request. That for sure is going to be out there. But sometimes we got voluminous materials. We may have a whole stack of papers that we're going to go through. In that case, put them up on a screen in the county boardroom so that people can see what it is that the county board is looking at, the members are looking at. I don't have a problem with that. All right, now we're in the chat again. A meeting where board members are approving payments to foster parents, kinship providers, vendors, etc., with consumer initials, sometimes by accident, sometimes it's HIPAA protected information, is appropriate to hold it in closed session, and if so, under what exception? I think in that circumstance, you're probably dealing with 1F or potentially 1E. With vendors, especially if we're negotiating contracts, it'd be 1E. If it's 1F on personal, social, medical histories that ought to be maintained in confidence, it would be 1F. Again, talk to your corporation counsel because they are going to be able to tell you with specificity exactly what section, if it applies, ought to be utilized. Currently, we only allow virtual meetings at the call of the chair. Is this a concern if we don't do it for all meetings? No, it's not a concern because you don't have to do virtual meetings. And if the chair calls a virtual meeting, then you flip over and you have to comply with the open meetings law under the virtual environment. And there are tips contained within this presentation for doing so. So it's not a problem that you don't do it for all meetings. Again, I know a lot of counties have gone to an environment where they put their meetings up on YouTube or some other streaming service so that people can look at the meetings. You're not required to do that, but I see that as a great opportunity to, again, provide transparency. So you can do that. Where would a board rule about being present virtually be documented in the bylaws? Potentially in the bylaws. If you go back to our presentations previously, dealing with board rules, we always say to codify your board rules in ordinance. And so if you codify those board rules in ordinance, they're going to be contained within your ordinances. But I know other counties that don't codify their board rules in ordinance. And so they're going to be just a document entitled board rules or something of that nature. And there are some counties that maintain bylaws. You might have them in the bylaws as well. Next, when attending a meeting by Zoom, should the county board supervisor be present in the video or is a picture sufficient? Always, and this is in the tips, always have the video camera on because we want to make sure that the board supervisor is there, and equally important that the board supervisor is alone as it relates to this. And so I always say that if we're in the meeting that we have the video camera on. If we're going to recess, then the supervisor can turn the camera off, but I very much prefer for people to have their camera on, which is why I insisted on Sarah having her camera on this entire time as well. Oh, there she is. All right, Sarah, we're at the end. We've gone through all questions, and I think I've won the speed talking award of the century here. So I'm going to look, we've got one more point in the chat. Oh, the presentation was helpful and informative. Thank you. You're very welcome. I'm glad to hear those comments. So Sarah, you want to talk about the big reveal that you spoke about at the beginning?
Yes, I do. First, though, I want to mention next month's in the boardroom presentation will be held on April 26th, where we will tackle the code of ethics for local government officials. But I also want everybody to watch their inboxes for an announcement on part 2 of the solar webinar. For those of you who were with us last month, there is a lot to talk about with regard to solar. There were so many questions, a lot of great discussion that we didn't get through the presentation, and a few additional issues were raised at that point as well. So we are going to be holding part 2 of the solar webinar on April 3rd, beginning at noon. So it will be outside of our usual 4th Wednesday of the month because we already had those scheduled out for several months. But again, watch your inbox for an invitation to join us on April 3rd as well for part 2 of solar. So with that, I think that concludes our program for today. Thank you so much for joining us, and we hope to see you next month.
Thank you, everybody. Look forward to seeing you on the 3rd and next month. Thanks.